welcome to Lecture 23. Our topic today is patient rights and responsibilities. And there are a lot of patient rights, relatively small number of responsibilities. And we're not going to go over every single one that is out there on the patient rights side. And we're probably not going to find all the ones on their responsibilities either. But hopefully the ones that we go over today will be most applicable to you in your work in the future. So today we have four learning objectives. One is to recognize the sources of patient rights. I'm not sure sources is the right word, but it's the only one that came to mind for me. And then we want to recall some of the important legal cases that that impact patient rights, and legal cases are one of the sources that kind of have determined what rights that patients have. And then we want to understand important patient rights and also understand important patient responsibilities. And I think one way to look at patient rights is also from the provider side, from your side, as your obligations to the patients. And then patients, they're a little hard for us to control, but they should have obligations as well. So we'll touch on a few of those. So what are the sources of patient rights? I think the first one is really just our ethical standards, and specifically the ethical standard of autonomy, which essentially just means self-rule. And to quote bioethicist Bernard Lowe, he defines his autonomy as that people should be allowed to shape their lives in accordance with their core values and to be free from unwanted bodily intrusion or touching. And that is kind of the ethical side, but our legal system, our legislators have also helped to further define that. And on the area of federal law, one of the big laws is that passed in 1990, and we will talk about a legal case that kind of prompted the passage of this bill, which is the Patient Self-Determination Act of 1990. Then there are also state laws. And again, it's important to note that states can add rights or give rights to patients or put additional obligation on providers. However, they cannot be less than or take away from the federal requirements. So the federal law really is kind of I guess a base level, and the states can add to that. And then kind of mentioned just legal cases out there. So we're going to talk about just about three of those. So the first case that's good to know about is one is called Schullendorf versus the Society of New York Hospital, and this occurred about over 100, almost 110 years ago, in 1914. Ms. Schullendorf went to the Society of New York Hospital. The physicians there thought that she may have fibroids and recommended surgery. And she stated that she did not want to have the surgery, but then the surgeons recommended that we would really like to do an exploratory surgery. So they did the surgery on her with the use of ether, and actually removed some of her body parts. And following that, she developed gangrene and had to have some further surgeries. So this went to court, and what the court decided was that basically that performing an operation without consent is assault. Okay, unless even back in 1914 they did recognize that there were emergencies. So if the patient had been unconscious when they showed up and you did something that the patient really didn't want to happen, you would be okay. But she was certainly able to make her own decisions. The doctor went against the decision, performed a surgery, a procedure that the patient didn't want, and the surgeon was basically charged with assault and battery, just like beating somebody on the street. An interesting side note for this case is that it was only the surgeon who was charged in this case and found guilty. The hospital itself was not guilty. So in 1914, if a surgeon or an employee did something wrong, the hospital itself was not culpable. However, that changed in 1957, I believe, with another case, so that if a surgeon does something that's not correct, the employer, the hospital, or whoever is in charge can also be found liable. So anyway, that's Schellendorf versus the Society of New York Hospital. The next case involved a young woman by the name of Nancy Cruzan. And Nancy had been in an automobile accident. She was 33 years old at the time. She went into a persistent vegetative state, and they about a month after the accident, they inserted a feeding tube. But the physicians, the family soon realized that she was not going to improve, and her parents asked that the feeding tube be discontinued. But it was a state hospital that was taking care of her, and the hospital requested that the legal system make a decision on whether or not the feeding tube could be removed. And the Supreme Court of Missouri basically ended up ruling that incompetent patients do not have the right to refuse care because, well, they can't make a decision. They can't speak for themselves. And what happened after that is it went to the U.S. Supreme Court, who voted on 5-4, that basically affirmed the ruling of the Missouri Department of Health, and basically said that the states, not the federal government, is the party that needs to establish policies and procedures to prevent abuses in this type of situation, and also allow the state to err on the side of continued life support. And kind of a result of this was the Patient Self-Determination Act of 1990, which established we'll talk about this more in a few moments, the requirement, not necessarily a requirement, can't make somebody have an advance directive, but to kind of put policies and procedures in place so that people have the opportunity to determine what in advance, to document in advance what they would like done to them in event something happens. Now, with Ms. Cruzan, following the Supreme Court decision, the Cruzan family went back to the state of Missouri. They opened up the case again, and based on some information that was not known before, being there were other people who testified that Ms. Cruzan had decided or stated that she'd never want to be on life support or statements like that. And when that was presented to the court made the decision that it would be justified to remove her life support. And so that was done, and she I think passed away a short time after that. And then just another kind of almost a little bit of a similar situation was a young woman by the name of Karen Quinlan. She had gone off to college and decided she desired to lose weight quickly, so she didn't eat food for a couple of days, went to a party, took a drug, Valium, along with a significant quantity of gin and tonic, and basically went into a coma after that. According to what I read, she was trying to fit into a dress that she had purchased, and so was trying to lose weight quickly. So it's a very sad situation. But she went also into a persistent vegetative state, and her parents, realized that she wasn't going to come out of this, and they wanted to remove the life support that was being provided to her. However, what happened there is the state intervened, thinking that this to remove life support kind of is like equivalent to like murder, and so, but in the end the court decided that a guardian, the parents in this situation, could exercise this right or this decision on the patient's behalf, even though they were incompetent. And kind of an implication of this, or something that came out of this, or result, is that hospital ethics committees have now, in a lot of situations, being able to address these types of issues instead of the courts. So when you look at these three cases, and there's certainly many others that are out there, but when you look at Schillendorf, the main thing is that you do something to a patient that they have not consented to, it's assault and battery, basically. Cruzan and kind of resulted in advanced directives, and again we'll talk about that in a moment. And then Quinlan is that other people can make decisions on other people's behalf. All right, now there are a lot of patient rights. These are 23 that I identified. You do not have to know this list. Please don't memorize this list. But there are about 11 of them that I want to talk about just a little bit, hopefully not in too much detail. So the first one I want to talk about, and I think this is really applicable to what you guys are going to do, is to remember that patients should ask questions. They might ask questions, but patients have the right to ask you questions. And doing a little bit of research, what type of questions might they ask you? What kind of anesthesia will I get? Various kinds. How will I feel when I wake up? What will you do to make sure I don't wake up feeling queasy? What are you going to do to prevent? How are you going to make sure that I don't have a wrong site surgery? They probably won't ask you that. They might ask the surgeon that, or the nurse that, but they could ask you that as well. Will I be aware of what is happening? Will someone be watching to make sure that I am okay? And how soon will I wake up? My experience with anesthesia is relatively limited. I know I went to sleep. I have no idea how long I was asleep. I just woke up and I didn't feel bad, and it was kind of a wonderful experience, I guess. One of the best sleeps I'd had in a while. But a lot of people, and the stuff I was having wasn't that risky. It's pretty common stuff. But a lot of people will come into a situation and just have a lot of questions about it. So one thing to remember is that it may be irritating sometimes when they're asking questions. If you have a really busy day, but they have the right to ask those questions, and you have a responsibility to answer them. So and all the anesthesia folks I've run with were just fantastic. So but they're just incredibly nice. The one question I had, they just answered it and they moved on, and everything was wonderful. But anyway, so they ask, try to give them an answer. All right. Patients also have the right to know their rights and also to have an explanation of their rights. I know many of you have been to healthcare, even just to a physician's office, and you will receive, if you go to a hospital, a written statement of the patient's rights. Um, you also receive a notice of privacy standards regarding HIPAA. I mean, you also get that from your bank and seems like credit card company and everybody else about privacy standards. So it's something that we used to, and I don't think many people actually read what those rights are. Usually the print's too small. But if people, if you are ever asked a question, you probably won't be asked a question on things like this. But if it's asked, then they should be, again, just like any other question, should be answered. And if you don't know the answer, it's okay to direct them to somebody who does. The third right is that they have the right to addressing special needs. And what do we mean by that? It could be, their English is not their first language. Patients have a right to an interpreter. Fortunately, today that's much easier than it used to be. A long time ago, all you had was, hopefully you had somebody in your community who might speak the language, but that was pretty rare. But today, a lot of that can be done, through online interpreters, and it's actually quite, kind of quite expensive. Within our medical practice, we had a pediatric practice here in Virginia. Occasionally, we'd have to have an interpreter, and we could pay $100 for an interpreter's time. And kind of an issue was that, well, the insurance company doesn't pay for interpreters, Medicaid doesn't pay for interpreters, and the cost of the interpreter was often more than the cost what we would receive from the insurance company or the payer. But the fact of the matter is that doesn't matter. You still have to provide them. And so then people may also have physical needs or mental disabilities that need to be addressed as well. So if you encounter a patient who's having these issues, probably by the time you're seeing them, others have recognized this need. But if they need it and you see it, you may want to intervene and see what you can do to address those needs. And another thing that, again, this is just a sort of a little thing, but I think is so very important is that patients have the right to know who's taking care of them. And so a recommendation that I have is every time you meet a patient, for the first time, the second time or the third time, introduce yourself, what your profession is, and the role that you will be playing. Having worked in at a hospital where we had a number of physician assistants working for orthopedic surgeons, people often thought the physician assistants were physicians, and that was a little misleading. And the physician assistants, frankly, never said they weren't physicians. And back then we didn't have name tags or whatever that were that you see around hospitals now. But you don't want to misrepresent yourself. And I think most patients do want to know who you are. And just also recognize that a patient can refuse you. They, for whatever reason, they don't want to be seen by, for in your case, they may not wish to have an anesthesiologist assistant take care of them. They may prefer to have an anesthesiologist. I've never heard of that happening ever in any profession, but they do have the right to do that. So it's up to them. Another thing, kind of related back to a couple of the law cases I talked about before, is that patients have the right to appoint decision makers and to execute advance directives. The decision makers, or what a patient can do, is basically have what's known as a healthcare proxy. Other terms for this are a durable power of attorney or medical power of attorney. And the healthcare proxy is a legal document that essentially names someone to make decisions on an individual's behalf. So I could name my wife or my brother or some other person, to make those decisions. However, they have to make decisions or that are basically defined, as those are defined in instructions that are provided by a patient. So I could decide that, if this type of thing happens, then you can do A, B, and C, or oh, you're never going to put me on a ventilator, regardless of whatever the situation is. Whatever I come up with, then the healthcare power of attorney, durable power of attorney, has to abide by those instructions. And it's sometimes I've read cases where family members may, perhaps a wife wants the patient to do, or the physician to do something that the patient is defined as not wanting done. And I think while it'd be a very, very hard situation to tell the wife that, no, I'm sorry, I can't do that because your husband said this is how I want it done. That the request of the patient has to be honored, regardless of what other people feel. And then the medical power of attorney, durable power of attorney, also has to make decisions that respect the patient's moral and religious beliefs. And an example of might be that, say, a non-Jehovah's Witness is appointed to be the medical power of attorney for a Jehovah's Witness. And many of you may know that Jehovah's Witnesses do not, based on their beliefs, permit the giving of blood and blood products. So, I may not agree with that, but that's their religious belief, and I would need to abide by it. So the durable power of attorney is someone appointed to make decisions, and those decisions should be driven by what is known as an advance directive, which is basically the written directions that a provider is to take in the event the patient is no longer, or the provider or the medical power of attorney is to advise the provider to make in the event that the patient cannot speak for themselves. So usually what's included in those is the care the patient would not or would like to receive. It's not limited to terminal illnesses. Living wills actually is kind of a type of advance directive, which is more focused on end of life care decisions. But something to remember about advance directives is that they are state specific, and what you can do in Alabama may be different than what you can do here in Virginia. So you just need to be aware of it. And while most of you guys are young and healthy and don't think anything is going to happen to you tomorrow, I do strongly advise that these are things that you want to put in place. When you look at cases like Nancy Cruzan or Karen Quinlan, automobile accidents can happen any day. So take some time and get that put together when you get a chance sometime soon, if you already haven't done so. All right, and then patients have a right to compassionate care, which is basically being free from harassment, verbal and physical abuse, and respectful of the patient's personal beliefs. Don't sound like I'm picking on Jehovah's Witnesses. They're just a common example that is found out there. Is that a lot of us would disagree with that personal belief, but we need to be respectful of it. Patients also have the right to have an informed consent for procedures and treatments. Um, They have to have the information to make an informed decision. So what that typically involves is that someone will sit down before a procedure to talk about the risk. If they're having a surgical procedure, they're going to be anesthesia risk. Um, you know, uh, you could have an adverse reaction, possibly. Again, I don't do it. Y'all are going to know way more about this if you already have learned about it already. But there are some risks associated with anesthesia. So if certain types of anesthesia are going to be given, then the patient should know about those risks. They also should know about the benefits. Oh, if you take the anesthesia, you won't feel the procedure. And it also probably makes for a better, makes it a much easier procedure. And then, what are all alternatives, you know, um, that are available? So an orthopedic surgeon might have a certain surgical approach to addressing a problem, but there may be non-surgical approaches as well that the patient might want to consider. And the patients also should be given information about the illness itself and what are the prospects for recovery. Now, being healthcare professionals, one of the things you're doing is you're learning a kind of a different language of that is used within the profession. But it's important to make sure that when informed consents are being provided, that they're understandable to the individual who is receiving it. And just kind of a funny example here in Southwest Virginia is a doctor who I met with one day. We were interviewing him for a job here at VCOM, and he was talking about the need about, when you're talking to people from the back hills of Southwest Virginia, you really have to speak their language. And he gave the example, they're never going to understand gastro-reflux disease. And, he said the way he explained it was, well, that's when acid goes back up your swaller pipe. And I guess that's what it is. And, his patients could understand that. And that's not probably something you would use, in what you do. But if you're involved in, providing a consent for anesthesia, make sure that you can make it as understandable as possible. And then, where possible, particularly for the big procedures and everything, is make sure you document what's going on. And when a lot of things you don't necessarily need to document it because it's part of a procedure. Healthcare does involve touching patients, but it's always a good idea to get their verbal consent before moving forward with anything. And then I think the last one I'm going to talk about is just the right to refuse treatment. Um, a competent patient can refuse treatment. And so just the example again, an adult Jehovah's Witness can refuse blood transfusions. And there are some exceptions to that. And an exception one is children of Jehovah's Witnesses. And what the courts have ruled is that an adult Jehovah's Witness, and the words used by the court, or cannot make a martyr out of their children. So it doesn't apply to children. And also, just to recognize, again, not sure how this would impact you in your role, but when patients show up at an emergency room, they are essentially consenting to treatment, even if they're unconscious. So the right thing to do is to take care of them. And Jehovah's Witnesses typically carry documentation on themselves, so there's a good chance that you may be able to, the team may be able to figure that out. However, if nothing's found and the patient's a Jehovah's Witness and they're unconscious and you give them a blood transfusion because they showed up in an emergency room, then I don't think anybody would. I don't think the courts would rule against them. So that's just a 7 or 8 patient rights that might be helpful for you to remember going forward. So we're just going to spend just a few more minutes talking about patient responsibilities. And so there's only one slide on patient responsibilities. And you know, you should expect these of your patients. Whether all of them will do it or not, probably not. But in terms of your doing your job, I guess your nurses will be involved in this too. But it's helpful to know, yeah, what the patient's medication record is. What are they taking? This can be a very time-consuming thing because oftentimes patients don't know what they're taking. Had a physician friend of mine who, when he got a new patient, he would tell the patient to, bring the bottle of every single medication that you're taking to your appointment, and he would sit down with them and go through every single bottle to find out what they were taking and the frequency, etc., so that he could get rid of the stuff they didn't need and you know check for um, adverse I can't remember it. Drugs that you should, incompatible drugs. But it's very, very important for patients to do that. You hope your patients are going to show up and also provide a complete medical history. Um, I think in what you guys do, if a patient doesn't share something that could have an adverse impact when they receive anesthesia. But that would not be on the anesthesia team. That would be more on the patient if they didn't share that information. And patients also need to follow treatment plans and also just kind of ask questions. So I know it's heartbreaking to have a presentation that doesn't go the full time, but I think these are some of the main things you may wish to know about patient rights and responsibilities. So I hope you have a good rest of the day. Thanks.